Hi everyone, welcome to our YouTube channel. In today's episode, we'll be talking about the relationship between employer-employee and various obligations that each employer and employee must take in the relationship. To help us today, we have Henry from Bentley's Queensland. Thank you, Henry, for joining us.
Always a pleasure, Sharon.
Henry, when we talk about employer-employee relationship, technically we can sort of see it in two perspectives, the legal perspective as well as the accounting. In terms of accounting, what sort of documents do you look at or factors do you consider to establish that kind of relationship?
First thing we always consider is the contract. Have you got an employment contract? If not, it always defaults to a standard understanding of what constitutes an employer-employee relationship. From there, additional things that may not form into the actual contract involves us finding out whether or not you've signed a MYG withholding declaration, super nomination forms, identifying factors such as whether or not you're a permanent resident, citizen, holiday maker, or even a student. All of these do come in and must be reported to the ATO via a declaration. Now, that's the basis of what constitutes for us a relevant documentation from an accounting purpose. But how about from a legal perspective? Is it slightly different or is it something entirely?
Well, I think you mentioned about the agreement part. So generally in the legal perspective, we really look at the terms that's set out in the agreement. But in the recent years, there's been a lot of regulatory changes. ATO has different requirements, Fair Work has different requirements, as well as Employment Act that's been changing. With Fair Work every year, they amend regulations and they have stricter compliance requirements. So that's how we look at it, but also probably other documents that can prove the relationship. I mean, they may say, oh, they're not an employee of the employer, but if you really look into it really carefully, they do have that relationship. So for example, what we call a sham contractor, which we will talk about later, for tax purposes or superannuation to avoid that, what they tend to do is say, well, they're independent contractors. Well, not really at the end of the day. So we really look at that part. But secondly, we also look at the accounting parts as well. There's a lot of rumors out there in the market, which is basically saying if you give cash payments, it's okay. Or if they get approached by Fair Work because of a complaint, they go, oh, I never understood the modern awards or the Employment National Standards requirements because it was all in English and English is not my first language. But that's becoming more and more difficult with Fair Work, kindly providing multiple languages of explanation of modern awards and their requirements.
It's no longer a valid excuse of ignorance or I don't understand. It just doesn't, it no longer stands up.
Yeah, and that really brings back again to, our common theme in every single episode is the importance of documentations and transparency. More and more with single touch pay and possible talks about expanding that to how many hours worked being monitored by the ATO. That really pushes businesses to be transparent about their business, how they pay the employees. So there's nothing wrong going on. And honestly, at the end of the day, there are people who make honest mistakes, but that's where really the appointed accountant or the lawyer should have picked that up in the first place.
Well, other than that, what are some obligations really we, or people as employees, must provide their employers, and vice versa? What does an employer have to do for their employees other than of course, the obvious?
Well, the legal sort of side is definitely identification's a big part. If, as you said, there's a lot of working holiday visa people, employees, student visa holders, or maybe the other different classes of people through special skills, so they have certain skills like chef, accreditations. You have to really make sure you have all the information that really supports that. So identity. So make sure there's they're not an avatar, especially that's common in backpacking. So tomato picking, strawberry picking in remote areas. Part of to go to working holiday visa too, a lot of people undertake that, but because they don't want to work at the farms, they use other people to replace them. And that comes through eventually. So those ones you just need to be aware of and say, well, as an employer, I'm going to be responsible if Fair Work doesn't audit. do I have the right identification? So you would request for visa checks and various other visa documentations to prove that they have working compliance visas. Second thing is if there's any restrictions, you understand them. And then thirdly is the accreditation. So whether it be from, if you're a lawyer or accountant, you make sure they have the correct accreditations in place, certification. You do background check just to make sure that it is correct.
Especially in sensitive departments, should we say, that deals with, say, children, or making sure that necessary staff have blue cards, as an example?
Yes, that's correct. And from reputable places as well. So even with bars, you sort of say, oh, do you have RSA? Yes, I have. Well, don't assume that they do. Ask for accreditation, see where they got that accreditation from. So that's quite important. Thirdly is do you have the right expectations of that job description that's been provided to them? So having that sort of understanding, a clear, coherent understanding of the relationship and what you'll be required to do as an employee and what employer will provide you, becomes adamantly one of the most important parts of an employment agreement.
Well, from an accounting perspective, it's very similar obligations, what the employer must have to the employee. In addition to all of the documentations for us, what we've seen is employees must give their employers actually a super choice form, must give that PAYG registration and pretty much a staff application form that gets lodged to the HEO. That is quite vital as a first step, simply because just in case the HEO turns around and say, who are these people that are working? Are they really holiday makers? Are they really part-timers? Are they really citizens or permanent residents? That form is a declaration by your staff to you that says, as you've mentioned, are they holiday makers? What's their bank account? What super do they choose? And all the other declarations that is quite vital in regards to saying, I have done my work, my obligation as an employer. If they have nominated, say, a wrong super fund, a wrong address, or a wrong bank account, they cannot come back and say, Henry, Sharon, you did not pay me. You could happily turn around and say, this is what you said, this is what you wrote. To us, that's quite vital as a step one.
Yeah. The danger I see a lot of clients fall into is, especially in sort of migrant-owned businesses, is employers will approach them and say, I want a cash payment. You don't have to pay me super. You don't, just give that to me in cash instead. And sometimes, you're desperate because you're in your business, you want to work with someone who speaks your language. So they do go through that, or through simple mistakes where they're like, oh, start on Monday. And without really getting all the paperwork, it's just a nominated superannuation fund details or anything like that, they commence work. And usually, if you're especially in the restaurant or takeaway business, some employees stop working after the second day because they think, oh my God, making sushi is so difficult, I'm just going to give up. So then you don't have the super details, and later on when you're trying to be compliant, there's nothing you can do about it. So the dangers are always there in terms of clients, in terms of their business daily activities and trying to be legally compliant as well. Completely
agree. And that fine balance, should we say, whether or not they stayed for half a day even, or a few hours and then disappear completely, is Fair Works, HEO, anybody can come along and say, Sharon, you have not complied with our rules, and technically they are right. You are the person being, the employer is the person in trouble. Now with the government using single touch payroll, you can't really hide that much, in the sense that in the good old days, for example, super, maybe you haven't paid out a staff super, or you haven't paid out leave within what you've stipulated in the contract, or as per your legal requirements, annual leave accrued, let's say, when they leave. It is now no longer the employee and employer relationship. It is now involved with the HEO, where they can now identify, you have not paid out this person's leave, you have not paid out this person's super, etc., etc. They have all that information straight away.
And that's the difficult part, which I understand a lot of where the clients are. Unless you're in this industry like we are, where it's ever changing, we understand it, we have to be on top of it. With businesses, because they're so busy running their daily activities, they really don't understand the implications of not being compliant with the new regulations that's out there. So the modern awards, definitely, there's so many different conditions there that allows flexibility, which a lot of clients aren't aware of. For example, provision 7 of every award allows for arrangements to be done. Various variations can be made in the employment agreement, provided that they're better off at the end to go with the employment agreement rather than the modern award. So having a lawyer who really understands that, or in collaboration with accountant, because obviously there's always the accounting side that comes with it. So making clear of what full-time, part-time, casual positions are, make it clear to say, well, if you don't fall into the category of casual, then you're part-time. If you're not part-time, then you're full-time. And if there's various benefits, generally a lot of people give meal entitlements. So they give free meals at the locations, or maybe they do fuel or transportation benefits, but they don't consider that as something which you can balance it out in your employment contract. So they're better off. A lot of people think, I'll just get them to sign onto an annual salary, then I can require them to work reasonable additional hours in the work, and I can get away with it. Well, no, and this generally happens in a lot of hospitality sectors where they hire you for full time and they go, time to time we'll require you to work additional hours. What they don't realize is the modern award clearly, and NES clearly provides that if the additional hours not evened out through flexible arrangements, so you can go home early, the next day, the next week, or you can adjust it with time off, then it's classified as overtime.
It is these little things I find that not only from a legal perspective, from an accounting perspective, we find, you mentioned awards. Which awards?
Yes.
Should they do? Should we say the absolute minimum pay, or is it based on experience? Is it based on industry? Is it based on number of years experience that the staff may have? What about certain skills that the staff may need? All of this actually impacts which award you go into. And I find that most, not all, some businesses do struggle to find out what awards is appropriate for their industry.
Yes, and sometimes because they don't understand the terms of the modern awards at the NES and the Employment Act, which resides over the Commonwealth jurisdiction, they don't know what information to give to their accountants or their lawyers. And that's why a lot of...
Or how to pick the appropriate awards.
Yes, that's correct. Yeah. So sometimes, we get complaints from employees coming in, we kind of review it, and the accountant, the appointing accountant for the employer has no idea, because what they get given is, well, on Xero, you only work 38 hours. I don't know that you worked overtime hours. And then you see the roster, which the employee has, and it clearly shows, which has been issued by the employer, that they've worked certain hours, which is exceedingly above and beyond reasonable additional hours.
Well, then I'd say that goes beyond accounting records now. Is more that they really, really, really do need to understand the ins and outs of not only the accounting requirements, but also the law in regards to that employment.
And how to calculate that. So I think it's both the job of the accountant and the lawyer to explain that, if they work beyond 10 p.m. there's going to be night, additional penalty rates, or if you're working in early hours in the morning, the penalty rates are quite really high. Things like that, they need to be weekend rates apply, public holiday rates. A lot of people know about public holiday rates and normal general dates, but nighttime or early hour mornings, they don't understand there's a very significant penalty rates that comes with that. So that's very different. But obviously, this is different to, for example, BH Billiton when you're working in mining sectors.
They would have factored all of that in.
Yeah, so it's all different. But that's why I recommend, for clients to really have acute understanding. Talk with the accountant, make sure you put measures in place, because from my understanding, you can have measures in place in Xero, which you can put into the program to really make it clear so the accountant really understands what's going on.
Really, whether it be QuickBooks, Xero, even pen and paper, the accounting records is a reflection of your business. It is very, very important. I cannot stress this enough that the reflection of what is in Xero is reflects what is actually happening, because as accountants we rely on Xero to be a true reflection. If Xero is not a true reflection, we on a day-to-day basis, we do not see the rosters, we do not see the daily operations. So hence we rely on Xero being an accurate representation of what the business does, and on a payroll function, who these employees are, how many hours they work, whether or not they were part-time, full-time, Australian, holiday maker, foreign person, or if they're a contractor.
Yes.
Oh, not a contractor, a casual. As a little note for those who may not know, casuals what's the difference between a casual and a part-time or a full-time? Long story short, casuals don't get leave. Part-time and full-time get leave, holiday leave.
But that's being blurred as well due to recent court cases where they said, well, if the casuals are working consistently certain type of hours, they can be classified as a part-time, which means later on, 2 years later, they can turn around and say, well, actually, I'm a part-time, so you have to now give me all the accrued leave I would have been entitled to.
Correct.
Working under it. So it's really a fine line. I guess the lines of the jurisdictions of the legal means are always changing, and really unless you have an accountant who's savvy, like Bentley's, who are aware of the legal implications as well, working with you, it becomes really hard, because ATO fair work, whether there's a fair work complaint for in the employee side or employer side, you need to prove the accounting as well as the employment conditions. So it comes hand in hand.
I will state then, in the event of an ATO audit or even a fair works audit, I believe, is the burden of proof is on you.
Yes.
So some clients that I have, especially if you do decide to pay in cash, say, or if those 1-2 employees that only work half a day and then disappear and you don't know how to pay them and you have no details of the super, etc. Yes, they may catch you out on that, but the importance of record keeping really, really does shine through in the case of such as an ATO audit or a fair works audit.
And that's absolutely right. So as you said, whether you're employer or employee, the onus of proof is always on the party that's making the complaint. If you're protecting as an employer, if you have evidence to refute, then that's great. As an employee, if you have strong evidence to say, no, I've been underpaid and here it is, then that's nothing really stronger than that.
No.
Yeah, the greater the evidence, the stronger we can always go for it. Which also brings me to in terms of disputes, which is fair work claims usually is about.
Yes.
A lot of people think that's just a legal issue, but it's an accounting and a legal issue.
It is.
It always goes hand in hand. With the fair work complaints, they really look at, did you make an amicable attempt at trying to resolve this nicely? A lot of employees make the mistake of going straight to fair work. Not that it's a bad thing, but in terms of, well, you can, but legality-wise, it's always good that you make reasonable efforts to resolve it directly with the employer. Should they fail because they don't respond accordingly and things like that, and if you have records, for example, where the employer is just dismissing you, not taking it seriously without a valid reason, then you can really take that to fair work, and that could build up your case. In terms of the employer, you always have an obligation to really take any complaint seriously. But what really sets the dispute resolution process is employment agreement. And what I found with a lot of my clients is when we draft it, we make sure that an internal complaint has to be submitted to our client or our firm first, and then for an internal investigation to be done, and then depending on the report, that will be submitted with the fair work claim. And the amount of times, a lot of it is just miscommunications, understanding between the employee and employee, which generally gets a lot of resolved. But also just clarity in terms of what the issues are. And even though we go to fair work, ombudsman to get it sorted, what we found in a lot of those cases where we are involved quite early is, ridiculous figures like, I want $50,000 of underpaid payment is suddenly reduced to, oh, okay, yeah, $2,000 what I want. So it really sets the expectations level as well.
I will also state, and to support that, what we've seen is where you have strong records and where you can track payments quite easily, is Xero or your online or your daily accounting records is extremely vital.
It's extremely, especially for the employer. When you're saying, no, I haven't underpaid it, what comes into the biggest play, not only for the legal side, there's not much we can do unless, it's in terms of the employment agreement, but always the balance of weight that's on the accounting Xero records of the business is incredible. And I think also if the employer or employee, whether it be, comes clean, which is very important to say, okay, yeah, I did ask for cash payments, or say, okay, well, yeah, I did pay my employees in cash. It's better for them to be transparent with us, because then sometimes most of the recommendation is, okay, but then be truthful to Fair Work, be truthful to ADO and say, okay, I screwed up. Fine, I did that. I won't do it again. And here's the protocols that I put in place with my accountant and my lawyer. Can you just forgive me one time? It's so much better than trying to fabricate things.
Do not fabricate things. It actually make things worse. And it just makes things very, very not only difficult, but also just makes it look very bad in terms of whether it be Fair Works, HR, and whoever is the person bringing the action against you.
So I guess that goes back to another constant theme in our episode, which is to be brutally honest to your accountant or your lawyer. We are bound by ethics code not to disclose any information. We don't think any information is stupid or anything like that. Every information is important. So if you do something illegal, and sometimes it's out of honesty, like you just didn't understand, maybe you didn't know the correct things.
A common example would be perhaps you forgot to pay out
superannuation. Yes, statutory entitlements.
Annual leave, accrued annual leave.
Yeah. Classification, or they just generally forgot to do overtime payments because they forgot to do it, or the roster clearly that the employee has, maybe due to a complaint comes in, we go, okay, well, here's a copy of the roster that they put with Fair Work. That doesn't match with your Xero, what's going on? And you turn around and go, okay, that week I was so busy, I forgot to do it, I'm so sorry. Tell us that, because then we can provide to Fair Work and say, well, actually, no, it wasn't intentional.
You have an excellent record as far as the Fair Works will be concerned in that particular audit, and that single mistake shouldn't be a major factor in their determination.
Yeah, and it is just a perfect period to really have a re-review of your accounting systems for your employees in terms of your business, especially with September coming to an end very soon. Fair Work, the Australian Tax Office are going to take a much more active steps moving forward. So if there's any accrued, statutory entitlements that you haven't paid, so if you haven't paid super for a really long time and you don't have a reasonable excuse, ATO will start taking actions. Same with Fair Work. They've been very lenient during this COVID period. COVID declared period by the government, which is from March to September, but that's coming to an end as well. And unless you're in Victoria, you really don't have an excuse as to why, if you're making good sales turnovers, why you're not paying your employees properly.
Absolutely agree. This sort of, I guess on the topic of employee, I want to expand further. We've touched on it, on the concept of a contractor. Well, in particular, a sham contractor.
Yeah, so in terms of sham contractors, a lot of people use it as a method not to pay superannuations or entitlements or insurances like work cover. So as an employee-employee relationship, you are meant to give various insurances and measures, work and health safety measures and stuff like that. When you have a contractor, then really the onus is on them to provide everything. So they tend to go through that, and the most common areas that they use sham contractors are constructions, tiling, cleaning industries and things like that. The danger with that is there's a really fine definition between an employee and an independent contractor.
From an accounting perspective, to me, what we've seen, an employee-employer relationship is an employee is paid by the hour for a and it's fixed for every week, whether it be 2 hours or 20 hours or 40 hours a week, you are paid for those particular hours. A contractor, in theory, is paid based on result. You are not paid based on, you come here and work for 2 hours to make my software. You are paid when the software is finished. You pay a particular person an X amount for a per project, and that is it.
So you can, but you can also do by hourly rate. So if you say, I estimate that it will take 20 hours for me to do this tiling work or cleaning work, hence I want to be paid at this amount, but at the hourly rate of this. So, I mean, as I said, there's a fine line in terms of line. I say is, well, a lot of people also do is, especially in the cleaning industries, they provide the equipment or they provide uniforms. Well, that automatically now falls into employee relationship,
Correct.
not a contractor one. The only way you can do that is if they purchase the uniform from you and there's an invoice generated to document that. If they're borrowing it, are they paying a hiring fee of those equipments that they're borrowing from you? Generally, I say don't provide equipment unless their equipment is broken, so temporarily just borrow it so they can execute the services. And there's a bunch of like legal sort of requirements that you can put in place for the independent contractors that you can do. But it's very exhaustive, and you really, unless you know what you're doing, don't go into the, independent contractor.
Just in case anyone is thinking, work cover covers only staff, and it doesn't include contractors and directors of the firm. Now, from my experience, people have entered into sham contractor employer, relationship to avoid one factor such as work cover. Payroll tax is a good one, superannuation. There are very, very, very specific rules that the ATO have put in place where if they have detected that even a contractor, in their determination due to certain very strict ATO rules, that if, for example, a contractor predominantly works for, say, MYG Legal, then MYG Legal may, even though this person isn't a genuine contractor, may have to pay super for this contractor.
Yes.
That factors even on payroll tax, work cover. They're onto it. They know that this is a common problem, and they have put in place rules and regulations to get around that. And where a service-based business contracts service providers to provide the service. Particular staff, I will say, a particular staff wears the uniforms, does everything as representative of the business, despite being classified as contractor and paid as contractor. This was actually taken by one of the contractors, and the ATO actually agreed that it is a employee-employee relationship. Now, you may ask, well, what does it mean for the business? This particular business actually was required to not only pay super on top of what they've paid to this contractor, but actually it is now under review whether or not it is paid under correct industry rates.
If you want to find more about whether you're really being compliant with all the relevant regulations and laws in terms of the accounting zero record softwares or in terms of your employment agreement, please don't hesitate to contact Henry or MYG Legal. We'll be more than willing to help. And as I kind of mentioned before during our episode, having a good accountant and a lawyer who actually also have a good collaborative work relationship, that's really important because it really goes hand in hand for it. So if I understand something's wrong with the accounting records, I can sort of cover it in the legal side if I'm aware of it, but if I'm not, then obviously it's going to be quite difficult for me to protect clients. Thank you for watching our episode today. I hope you found it very informative. To get more great information about your running a business in Australia, please subscribe to our YouTube channel.